All rise. In the Court of Criminal Division, the Queen against Jordan Monahan and others.
We are today handing down our written judgment in cases concerning the sentences of 4 offenders convicted of murder and 1 of manslaughter. They concern both applications for leave to appeal against sentence and also references by the Attorney General or Solicitor General for leave to refer sentences as unduly lenient. The cases are concerned with life imprisonment for murder and the circumstances in which no minimum term should be specified by the court and instead a whole life order made. The principles applicable to the imposition of a whole life term are well established. It was no part of the Attorney General's case that those principles should be changed or the bar lowered for the imposition of a whole life order. In our judgment, we have summarised the applicable principles and deal with each of the individual cases. The first concerns Ian Stewart. In February 2022, he was convicted of the murder of his wife, Diane Stewart. He committed that murder in 2010. He had been convicted in 2017 of the murder of his then fiancée, Helen Bailey. On the 9th of February 2022, he was sentenced to imprisonment for life with a whole life order. Stewart seeks leave to appeal against sentence. The circumstances of his case do not fall within the terms of the statutory provision which provides that a whole life order should be the normal starting point, subject to possible adjustment for the individual facts. It is not one of those rare cases where nonetheless a whole life order should be imposed. We grant leave to appeal and substitute a minimum term of 35 years. The second concerns Wayne Couzens, who pleaded guilty to kidnap and rape of Sarah Everard, and later he pleaded guilty to her murder. On the 30th of September 2021, he was sentenced to imprisonment for life for the murder with a whole life order. No separate penalty was imposed for the offences of kidnapping and rape. Couzens seeks leave to appeal against sentence. In his case, we grant leave to appeal against sentence but dismiss the appeal. Although the circumstances of his case do not fall within the terms of the statutory provision which provides that a whole life order should be the normal starting point, the individual facts are such that the judge was entitled exceptionally to impose a whole life order. The third concerns Jordan Monahan, who was convicted on the 17th of December 2021 of 3 counts of murder and 2 counts of attempted murder. Between January 2013 and October 2016, he murdered 2 of his children, Ruby at 3 weeks and Logan at 21 months. He twice attempted to murder his 3rd child. While on police bail when the deaths of his children were under investigation, he murdered his then partner, Evie Adams. He was sentenced to imprisonment for life with a minimum term of 40 years. The Solicitor General applies for leave to refer that sentence as unduly lenient. The circumstances of his case do not fall within the terms of the statutory provision which provides that a whole life order should be the normal starting point, subject to possible adjustment for the individual facts. It is not one of the rare cases where nonetheless a whole life order should be imposed. However, the court is satisfied that the minimum term imposed by the judge was unduly lenient and substituted a minimum term of 48 years. The fourth case concerns the death of 6-year-old Arthur Labinnio Hughes. On the 2nd of December 2021, Emma Tustin was convicted of his murder. She had pleaded guilty to 2 counts of child cruelty relating to him and was convicted of 2 more. Thomas Hughes was convicted of Arthur's manslaughter as an alternative to murder and 2 counts of child cruelty. He was Arthur's father. Tustin was his partner. On the 3rd of December 2021, Tustin was sentenced to imprisonment for life with a minimum term of 29 years, together with 10 years imprisonment on each count of child cruelty, to run concurrently. Hughes was sentenced to 21 years imprisonment for manslaughter and 9 years imprisonment on each count of child cruelty, to run concurrently. Both seek leave to appeal against sentence. The Attorney General seeks leave to refer both sentences as unduly lenient. We refuse Tustin leave to extend time or leave to appeal against sentence. Although we grant the Attorney General leave to refer the sentence of life imprisonment with a minimum term of 29 years for murder, we do not consider it unduly lenient. The circumstances of this case do not fall within the terms of the statutory provision, which provides that a whole life order should be the normal starting point following conviction for murder, subject to possible adjustment for the individual facts. It is not one of those rare cases where nonetheless a whole life order should be imposed. We refuse Hughes leave to appeal against sentence, but grant the Attorney General's application for leave to refer the sentence of 21 years imprisonment. Taking account of all the offending and the circumstances, we accept that the sentence is unduly lenient and substitute a sentence of 24 years imprisonment. Our full reasons are set out in the written judgment. That concludes this short hearing.
Court rise.